The defendant is charged with 1 count of assault or assault and battery. Today is the date set for review. Ms. Stevenson.
Janice Stevenson on behalf of Brianna Williams. Ms. Williams, ma'am, please unmute and tell the judge your full name.
Brianna Yvette Williams.
Thank you, ma'am. Today is the date set for review, and I didn't request Ms. Williams's update from probation. Her probation officer is off on leave, so I don't have an update from her for her, but just looking at the register of action, Ms. Williams was placed on probation by this court in March. So this is her first review. It was a 12-month delayed sentence. So she's not eligible for discharge yet. I did order her to do anger management. It doesn't say how many in the register. It says mental health counseling, urinalysis. Oh, I didn't sign a delayed sentence order. That's not, so apparently we didn't do an order back in March. And then I'm looking at the register and it says, in my absence, Judge Evans signed an order. That's probably why it doesn't say how many anger management classes.
Your Honor, may I?
You may.
I remember that day. I could not locate the original order. So when Judge Evans stood in, she signed another order, but then I found the one that you had signed on March the 10th, and I also forwarded that over to probation.
Okay, tell them to disregard that last order, because that if it's different from mine, disregard that, disregard it.
Okay.
So that's, yeah, we're gonna rescind that order from Judge Evans. We're gonna rescind that order. All right. Okay, so Ms. Stevenson, what does Ms. Williams think she's done already?
She has been in touch with Ms. O'Driscoll and has been waiting to hear what her exact conditions of probation are.
No, that's okay. Now y'all know that ain't the truth. Okay.
So, I mean, I'm going to say this on behalf of Ms. Williams, Your Honor. She has, she already has all of Ms. O'Driscoll's contact information. Most of my clients, when they get to this point, they don't have all that. And I do think she's kind of been, you know, in a place where she's waiting. If we could get a copy of the court's order if it could be emailed to me, and then I'll forward it to Ms. Williams. I gave her Eve's contact information today. She didn't know how many anger management classes she was supposed to take, so I encouraged her to go ahead and sign up for 12.
You mean she didn't remember? Because don't say I didn't say it on the day of her sentencing. So let's
yes,
she didn't remember.
It was supposed to be sent over to me. That's what it was supposed to be sent over.
Ms. Williams.
Williams, like I said what I said, and I'm saying it again. I didn't just check no boxes on a paper and say you'll get you'll get this paper. I didn't just check boxes on a paper.
If you rewind the video, you said you were going to send it to me.
Okay.
Can we go back to breakout, please, Judge?
You might
please.
need to, because Ms. Williams is ready to get this probation revoked.
Okay.
Now, go back on no video, because I've been doing this job for 15 years. And what I know without ever looking on a video is that out of my mouth, I said the terms and conditions of probation. And then at the end of that, I said, I will mail you a copy. But you need to go back and think, because first of all, she's coming in person. Because I'm sick of this right here. This whole little attitude she has.
We're right back.
Whole thing right here. Judge. This whole attitude right here.
Okay. If we could go back to breakout right now, please, Your Honor.
Yeah,
I would really appreciate it. She can ready to
go to jail. Go to breakout, because she can ready to go to jail. Let me close these rooms so you can talk to her. And let me say this, it's nothing funny going on in my courtroom right now. And there's only one person in my courtroom right now, which is probably why you're here on this assault and battery case that's in danger. Now, I don't know who you think I am or where you think you are, but let me be clear about something. My name is Judge Lanice Bryant, and I am presiding over this case. You're going to be respectful. You're not going to keep interrupting the court. You're not going to keep turning your head around and laughing, because I know how to do my job. I do it very well. In fact, I do it extremely well.
If we could go right away, Judge.
I know, because you scared. You like, Judge.
I am.
Okay. All right. Then I'm going to stop talking. Miss Stevenson, I'm going to stop talking. And then I'm going to do this right here.
Appreciate
and I'll
it, Judge.
So are we ready to go back on the record with Miss Williams?
We are, and I have an update of information for the court.
Okay, and I know you might tell me some stuff she's going through, but you're not going to come on here and be disrespectful to me. Miss Stevenson, go ahead.
Thank you very much, Your Honor. So Ms. Williams, this is our office's first interaction today with Ms. Williams, and I did have an opportunity to observe what was going on with Sister Counsel. And because, there are probably some resources available here at the court that Sister Counsel was not aware of. I think this case, having watched Ms. Williams in her prior hearings, having talked with her today, having watched the dramatic shift, Your Honor, in her demeanor from when she and I were in breakout till she came out before the court. She does have a mental health diagnosis. I don't know if a PSI was ever done. And I know probably maybe because it's sentencing, it looks like this one slipped under the radar because there was a substitute.
Well, her attorney was Ms. Marable. And
right. So she had retained counsel. We had a substitute judge at the sentencing, I think. And so I really would like Ms. Williams to be able to talk with someone from the specialty court. I don't know that we would be able to do that today. And if we can, that would be great. But I do think this would be a better fit if she's eligible. I forgot how Mr. Yancey called it. I like the word.
I did too. And I tried to say it yesterday, but I couldn't remember it.
Right. Behavioral special or something like that. I don't know. Yes. But I think if she's eligible, I think this is a better fit for the specialty court.
Well, let's see if we can get them on.
Okay.
Public Defender Chinazi Kiriaki Maruli on behalf of Mr. Jalen Foster. Mr. Foster, can you state your name for the record, please?
Jalen Foster.
Okay. I'm sorry about that, Judge. Your Honor, Mr. Foster is scheduled for sentencing today. I asked I asked Davi to let me know when Mr. Foster's case was called. Oh, sorry. We're just having connection issues.
All right, the 14B District Court is now back in session. Obviously, I'm having some computer challenges. I'm on a different computer now, and hopefully this will work. I will call the case of the State of Michigan versus Jalen Foster, case number 22-00801. APA Rachel McDuffie for the people.
Assistant Public Defender Chinazi Kiriaki Maruli, Your Honor, on behalf of Mr. Jalen Foster. Jalen, can you state your name for the record?
Jalen Foster.
Good afternoon, Mr. Foster. You need to remove your hat, please, sir.
Jalen Foster.
Thank you. We're here for today.
That is correct, Your Honor. I had an opportunity to review the report with Mr. Foster. Mr. Foster there are no modifications to be made to the body of the report. However, I did just want to make a statement. There was a statement in the report about their interpretation of Mr. Foster's position. I don't know if that is what led to the recommendation for 3 in-person 12-step meetings a week. That would be the only portion of the recommendation that we would be asking that the court not adopt. Specifically, Mr. Foster, I don't know if the court is aware, this was one of the cases that Mr. Foster was eager to get resolved against our recommendation. So when he now told probation that he just wanted to get this over with, I think probation took that as if Mr. Foster did not care about this matter. But I just wanted to let the court know that Mr. Foster has been very proactive with this case. He accepts responsibility for his particular actions in this case. And if that is the reason probation is recommending that he do 3 in-person meetings, we're asking that the court allow him at least to start off without having to do the in-person meetings. Mr. Foster indicates that he works a great deal of time. It's quite difficult for him because sometimes he's called in at the last minute for shifts. We don't know where he's never done any type of AA or treatment before. So he doesn't know location wise whether or not he'll be able to make it to 3 in-persons. He's not driving right now. All of his transportation is he depends on someone else for that transportation. So if it's possible for him to at least start off with the online weekly meetings, and as long as he's doing well in that, or if he's not doing well in that, then we can progress him up to an in-person requirement. That is just the request we have today. Other than that, Judge, we are okay with the recommendation.
Thank you. Ms. McDuffie?
So one thing I want to address before even getting into the recommendation is that the last time we were here, Mr. Foster admitted to a bond violation. He had a positive SoberLink result, and that was from a test on May 3rd. The judge the court advised Mr. Foster that he had 1 bite at this apple, but that he was going to jail if he drank or missed the test again. Since then, the most recent report from Community Corrections is labeled as a progress report, but Mr. Foster has missed 5 tests since then, between May 19th and June 14th. He retested for 1 of those, which was negative for alcohol, but all the rest of them had no retest, the most recent one being on June 14th. It is concerning, obviously, because this case involved alcohol. His drug tests have all been negative.
Is Mr. Foster still with us?
He's the iPhone.
Yes, I'm with you. Yes, it's a lot of background noise. I didn't want to interrupt you.
Yes, but your picture's missing also, and you're here for sentencing today. You can mute your device, but you need to stay on the screen, sir. All right, you may proceed.
Thank you, Ronna. So it's concerning, obviously, because alcohol is at issue in this case. And going back to the recommendation, he does have another OWI case that is currently pending with the pretrial later this month. So obviously that was the court's ruling with respect to him serving any jail time as a result of that. But I just wanted to make sure that that was on the record as a concern from the people. The people don't have any issue with the recommendation itself. My concern is, I understand Mr. Foster wants this. I think most defendants wants their matters to be over with, and whatever that means as quickly as possible. But my concern is that Mr. Foster is continuing to accumulate more cases that he wants to resolve quickly. So I think that my concern is not that he isn't taking this seriously in a way so much as he doesn't even comprehend what he needs to do to not commit offenses.
Thank you. Mr. Foster, is there something you would like to say before I sentence you, sir?
The shit he talks about, this is before, like, when I got arrested for that, I had never been in front of a judge. Like, I had never spoken. I haven't got any documents or anything. I just laid it on my blood. I haven't committed an offense since I've been dealing with this.
You saying you haven't committed any new offenses since you've been dealing with this court?
Yes. They brought me from Wayne County to Washington off, and that's when I started with Washington. It all started, both counties started on the same day.
I think the concern is, I mean, that is a part of the concern, obviously, if you were already in the system, so to speak, and then you had a new offense while you were under probation or a bond, but that's not the case. The concern is that you committed this offense on July 21st, and then in the interim time period, you committed another offense, both of them involving drinking and driving. So the concern is that you either have a severe drinking problem that would put you in jeopardy and putting other people's lives in danger, or that you have a complete disregard for the actual severity of your actions. So those are the two concerns. And I appreciate that you weren't on bond at the time that you committed the new offense, but nevertheless, it is a new offense. So this court has extreme concerns about whether or not you're going to follow the orders of the court, especially in light of the fact that it very clearly told you that you had your one bite at the apple and you still missed 5 additional testings.
Speak down.
It's up to your attorney.
Go ahead, Jalen.
I take it serious. I apologize. And I just ask if you give me mercy. You won't see. I'm gonna finish everything I gotta do on time. You're gonna see all the review. Then I'll be out there.
Judge, would the court consider a scram tether? I did talk to Jalen about that particular issue. He stated that transportation to and from was one of the difficulties that he was facing.
All right. All right, sir, it's the sentence of this court that you served 93 days in the Washington County Jail, credit for 2 days served, 91 is suspended, 5 days of community service, 12 months on probation, fines and court costs in a total of $695, $30 per month in probation oversight fee, complete an assessment at community corrections and follow all recommendations, sign a release of information. You are to attend the MAD Victim Impact Panel, complete the Armed Highway Safety course within 90 days of this sentencing, meet with probation when and where directed, including any and all home visits, no use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, and no being in the presence of anyone using or possessing those, no use or possession of any firearms, firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone using those. Drug and alcohol tests at any time is ordered by probation or police. And I will order the scram tether. Attend 12-step meetings 3 times per week. I'm going to allow you to have 2 of those be well, I'm gonna do it backwards. 1 in person. We'll do a review on September the 19th, 2023. At 10 a.m. I am also noting here, if you miss another test, well, we don't have to worry about that just yet because you are going to be on scram. But if you go back to testing and you miss a test, sir, then I will have you arrested. Understood?
Yeah.
In Your Honor, that would apply to scram violations, tampering, or consumption as well, right?
Correct. All right. We're all set. You need to contact the probation department this afternoon tomorrow morning after 9 a.m. so that they can schedule a time to go over your probation contract with you, okay?
I got a question.
Yes.
Do I need to contact community corrections right now, like for the stamp?
You
Is
do.
it a time limit I need to have it on?
Within 48 hours.
All right.
All right. Thank you.
Thanks.
Thank you, Judge.
Your Honor, after a discussion, Mr. Walter, are you still on?
Yeah, I'm still on. I'm sorry.
Thank you. After discussion with Mr. Walter tells me that he would like to admit to the bond violation.
All right, Mr. Walter, it's my understanding you're gonna waive your right to have the bond hearing in this matter and admit to the bond violation in this case. Is that correct?
Yes, ma'am.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
All right, thank you. You may lower your hand. Is it true, sir, that you missed tests on
Yeah.
May 24th, May 31st, June 8th, and June 15th?
Yes.
All right, I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Mr. LeBeau?
Yes, Your Honor.
Thank you. All right, I will deal with the pretrial first and then we'll go from there.
Thank you. With regard to the pretrial, we would ask for an adjournment as Mr. Walter has been referred by my office for a substance use assessment that we'd like for him to complete and for us to receive the results of.
Any objection?
No objection to the adjournment, but with respect to the bond violation, the people are going to request them for ETGs.
July 18, 2023 at 10 a.m. I think it should be 9 a.m. But you're requesting ETG testing? Is that what you said?
I'm requesting a sober link because his missed tests were the ETGs, and it sounds like part of the issue he was saying was transportation or having a place closer to him. So alcohol is really the main issue in this case.
Yes, Your Honor, and that is what Mr. Walter is requesting as well, either a sober link or a scram tether to permit him to comply with his testing obligations without needing to acquire transportation to Washington County.
All right. Sober link placement within 48 hours. And we'll, go ahead.
Mr. Walter, do you understand that you must report to community corrections in Washington County for the sober link within 48 hours?
What is sober link?
It's like it's scram tether, but you blow into it.
Oh, okay. Okay, within 48 hours, okay. And how much is this one?
$6 per day.
$6 per day, and it's just a one time?
No, you will be on a sober link, sir, until your case gets resolved.
Okay, so $6 a day for the sober. So the sober link is something that I have on in my control.
You need to speak with your attorney about all of that, sir.
Mr. Walter, I can give you a call after court.
Thank you.
Over this.
All right.
The court will call the case of Erica Wenzel, case number